Professor Gavaris.
Chairman Coble, Ranking Member Watt, members of the subcommittee, thank you for the invitation to appear before you today. I wish to begin by commending the subcommittee for its leadership in tackling this issue of utmost importance and economic significance. It is time, I believe, to embark on the process that will give us what the Register of Copyrights recently referred to as the next great Copyright Act, as was done 3 times in the past, 1790, 1909, and 1976. So much has happened since 1976, when personal computers, the Internet, and the digitization of music and the phenomenon of social media were not yet realities. Copyright should allow professional creators, whom I see as small businesses, to get a fair return on their creative investment when their work is successful in the marketplace. It should also allow many sustainable business models to flourish in producing, exporting, and providing access to U.S. copyrighted material around the world. Copyright should also be balanced. Individual users should have fair access to copyrighted material and be able to take advantage of the almost infinite possibilities that the Internet offers. As I explained in my written statement, making copyright work should focus on maximizing authorized uses of copyrighted material, because then everyone wins, instead of focusing solely on minimizing unauthorized uses. I believe that copyright modernization is necessary in part because copyright law is now everyone's business. It was not always so. Before the Internet and digital devices became what is now probably the most widely used way of accessing copyrighted material, individual consumers and users had few reasons to think about copyright in their daily lives. Copyright was a set of rights for and negotiated between professionals such as authors, publishers, record companies, and broadcasters. For them, dealing with complex rules was part of the cost of doing business. Individuals who purchased copies of works in the form of books, tapes, or CDs had ownership rights, in fact, in those copies. As a result, copyright constraints were mostly irrelevant in the daily lives of most Americans. That situation has changed dramatically. Accessing a song online, downloading an e-book, streaming a movie generally requires a license, which may restrict the uses that individuals can make of the material. Technological locks may also be in place. On the flip side, however, technology has made it much easier to copy, modify, and disseminate copies of material, including sometimes material that belongs to others. This points to the need to find also, and more importantly, the scope of exception. The international dimension is also relevant. I provide details in my written statement. Let me just say that the international picture is beginning to look like a patchwork of rules. I believe a comprehensive review of the statute should allow a clearer path for U.S. leadership in global copyright discussions. I would also like to say a few words, if I may, about licensing. Both individual and collective licensing have become an important vehicle through which creators and other rights holders monetize their creative work. Let me give a brief example of each. Collectively, many songwriters and publishers authorize performing rights organizations such as ASCAP or BMI to license musical works for broadcasting and streaming. Individually, authors and publishers may license, say, a foreign publisher to translate or publish an e-book or a book in another country. Whether the Internet will perform adequately in years as a market is in large measure a function of whether licensing can work. The statute contains 8 compulsory licenses. Those are usually fixes to temporary problems tend to become permanent. One of those licenses was first established for player pianos. In my written statement, I believe the best way forward is to leave some discretion to a specialized agency, such as the Copyright Office, to decide from time to time whether changes are required to those licenses, whether an existing license is still needed, or even whether a new one should be established. Finally, when you buy a car, the fact of the car's existence is not, unless perhaps you're a student of philosophy, one that most people would doubt. Registration may confirm things like the model or place of manufacture. For a copyrighted work, it could be the author, the publisher, or the year of publication. But buying a car requires a determination that the person selling the car has the title to the vehicle. This is where recordation of transfers comes into play. I believe that a heightened recordation requirement would ameliorate a number of issues, including orphan works. In closing, I commend the subcommittee for its leadership for this important endeavor and invite any questions that you may have. Thank you.
Thank you, Professor Gervais.